Hello, everyone. I'm Nipasa Pradhan, and welcome to Immigration and Jobs Talk Show. Very happy to have you all. Thank you for joining. So, we are streaming live in Facebook, LinkedIn, and YouTube. And I do hope that it's going to be a very, very enlightening session today, once again. And we are going to be joined by a very special guest who has joined us earlier also in other webinars we've had with him. And he is none other than Chan Parvathaneni, attorney from SPB Law Firm from Dallas, Texas. So without further ado, please help me welcome him back to the show. Hi, Chand. How are you doing?
Hello, Dipasa. Glad to be back here. Thank you so much.
Yes, super glad. Me too. And today is actually going to be a continuation of the topic we had last week, and that is F-1 OPT and CPT-based RFEs, navigating H-1B cap filings with confidence. And it was a superb, last week as well. It was very, very enlightening. Thank you for joining us. And I'm sure people out there also, whoever joined us last week, were benefited. And I'm sure it's going to do the same this week as well. So maybe let's do a small recap so that everybody out there can be with us on the same page. And yeah.
Sure. So March. So basically next month, March, the lottery filings will start. So everybody will try to get into the lottery. The employers will be filing for a lot of new employees, and the
Right.
lottery season will begin. And what that means is a lot of people who are on F1 visa, students out here in US, they will be trying their chance to get the H-1B for the very first time. So they're trying to convert from F1 status to H-1 status. And during this time, the most common RFE that we see deals with the students is either their OPT status or their CPT status. And this is a very common RFE, and sometimes it could be a little bit complex based on the facts. And what that basically means is all the students who are in US on F1 status, they should know the intricacies and the rules and regulations of OPT, which is optional practical training. They should know the rules and regulations of CPT. CPT again is optional. It is curriculum practical training. So everybody should be aware of what are the rules, what needs to be done, how much are they supposed to get paid, and where are they supposed to work at? Can they work for any company or not? So there are various regulations, what can be done and what cannot be done when somebody is participating in these two programs. And the RFEs are very common, but majority of the time people get an approval because 99% of the time I do see people trying to follow the rules and trying to do whatever is required out of them. And we had some very good conversations and discussed last week in the last episode about what are the most common kind of RFEs that we get, what are the kind of common questions that we get, how do we handle them. And we can utilize this session to dig further into these two issues, OPT and CPT. And we'll try to educate the folks out there on how can you do your job while working under these two programs, and at the same time ensure that you have all the right documentation to be successful when your H-1B lottery is picked up and your H-1B is filed, because this is a very common question and it can be handled very easily. It is just that you have to be prepared and make sure you have all the right documentation.
Absolutely. So this topic today, friends out there, we are, going to have a thorough examination for F1 OPT and CPT related issues. In fact, last week we even spoke about the criminal issues that people can probably go through. So, friends, if you missed it, please do not forget to go check out our previous episode under the same topic and with none other than Attorney Chand Parvathaneni. So, without further ado, let's dive into today's episode, because I still have a lot of questions and many things to discuss under the same topic. So, Chand, I hope you two are excited just as me and folks
Yes.
out there watching us.
Yes.
So, let's start with the first question I have for you, and that is what challenges do international students face during curricular practical training, that is CPT, and how can they, overcome them?
Sure. So again, for everybody out here, so curricular practical training, so CPT. So CPT is optional, and this is a feature where somebody, while they are still a student in some university, while they are a student, it gives them an option to go out in the world, go out into the industry, and actually start working in the industry. And the goal of this program is to help the students gain some practical knowledge in the field of their study. That being said, there are very, very strict rules over CPT, and that is what causes a lot of challenges. The reason is when somebody is a student, they're only supposed to work on campus. They're only supposed to work 20 hours on campus. They can't work for more than 20 hours, and even those 20 hours has to be on campus. So anytime a student is going out of campus and working, there is a big potential that somebody could disrupt the labor market. And what that means is the government, they have so many regulations around uh, what kind of permissions you require to actually go out of the campus and actually work while you are a student, and what are the requirements. And some of the requirements are very, very strict, which is what causes a lot of confusion. And main thing is CPT. CPT, again, in simple words, means you are a student, but you are going out into the industry and actually working in the industry, getting paid while you are still a student. So the main challenge is how do we get the authorization? So not everybody gets authorization for CPT. The general rule is one has to wait at least 9 months, finish 9 months of coursework, and only after that they will be eligible for CPT in general. That being said, there are some exceptions, and the exceptions are you have to prove if you want to work on CPT before the 9 months is up. There are some challenges, and those challenges are your degree program should actually require immediate participation in CPT. So not all schools and not all degree programs will require somebody to work in CPT on day one. So that is something what everybody should really, really carefully look at. Do not take up CPT employment before 9 months. And if you need to take immediate CPT, make sure you go to the school DSO. Make sure you look at the school program requirements. And that is one of the biggest challenge is ensuring that you actually get approved for CPT, and nobody should take CPT without the school DSO approving it. So there's a big process, and the big process is talk to your school DSO, see what your program requirements are. Only if it is allowed, participate in CPT. If not, do not participate in CPT. Another big challenge that we see is class attendance. One has to be very, very cautious. You have to be a full-time student. You have to attend classes, and the classes cannot be offline. They have to be online classes. You have to ensure class participation, and only along with that, you can take CPT. And even with all these things, the DSO still has to approve your CPT. With CPT, you get course credit. So there are all these nuances. And what that means is be very, very cautious. Talk to your school DSO before you even take CPT. That being said, if you do it right, you follow all the rules of CPT, it should not be a challenge. So overall, I think it is getting approved for working off campus using the CPT program, following all the rules. You do it right, you'll be fine.
Right. And is it different for everyone, or is there like a specific hour that you have to maintain while studying and still doing CPT?
So CPT generally means that somebody is still enrolled in the school. So every school will have
Right.
a certain number of credits to be a full-time student. So the school DSO will typically ensure that somebody is actually taking full course of study before they're permitted to do CPT. And what that means is the school's requirements could change, which is why the school DSO is the right person. So they have a CPT agreement, and they'll typically go through the CPT agreement, make sure the student understands it, the employer understands it, and they also
Okay.
try to make sure that the student is actually enrolling in the right number of classwork. So these things are actually done before the school will even approve a CPT. Not only that, even if school approves,
Okay.
sometimes USCIS down the line, they'll come back and ask some more RFEs. They'll have us prove that CPT is integral to the program. So they have a couple more requirements, which is why somebody really has to actually go in and look at the school CPT's requirement, talk to the school DSO, get some thorough information before they embark on the CPT journey.
Okay. Okay. Anyway, so there are folks out there already asking questions in YouTube. So, friends, I want to tell you that if you have questions to the attorney directly, do not forget to ask your questions in the comments, and we'll be very happy to take them up very soon in this episode. So, stay with us, all right? And Chand, I wanted to also know, can you discuss the importance of proper payment and compliance with employment regulations during F1 OPT and how applicants can ensure adherence?
Sure. So F1 OPT, somebody's working and somebody needs to get paid. And this is a very common question that USCIS comes and attacks us when we do the H-1B filings. They talk about the pay statements from OPT. And there is a lot of confusion in OPT because when students graduate, when students finish their coursework, they don't find a job immediately. So there is a lot of confusion on do I need to get paid? And if so, what is the minimum that I need to get paid? What will happen if I don't get paid and I have too much unemployment time? So this is a very common question. And so I'll briefly give you an overview of OPT and the wages. The general rule is if somebody finishes a program, they typically get 1 year of OPT. So OPT means optional practical training, and somebody could go and work anywhere in US in the field of their study. So if somebody is studying to be a computer scientist, so they can work in IT industry anywhere in US. The job has to be relevant to their course of study. That being said, OPT does require that everybody should be employed. And what that means is uh, OPT program requires somebody to work for 20 hours or more. So 20 is the minimum. So 20 hours or more is what they're expected to work. That is what the regulation says. That being said, because the government, they understand that not everybody can be employed at all times. People might lose their jobs. People might take time to find their jobs. There is a little bit of leeway. And that little bit of leeway is during the initial year of OPT, the very first year that somebody gets OPT, they can have unemployment. They can have unemployment of 90 days. And what that means is for 90 days, even if somebody is sitting at home, USCIS does not care. Nobody is violating any rules. One cannot just cross 90 days. So if you have 91 days, you are violating the rule. So you can have unemployment. You can have unemployment without getting paid for up to 90 days. Anything more than 90 days, there's a problem. So technically, in the first 1 year, at least for 9 months, one should be working for 20 or more hours. That is the general rule. Then the next big question is how much should I get paid during the OPT? There are very, very strict rules on the minimum wage in US. And the minimum wage in every state is different. The minimum wage in Texas is different from the minimum wage in some other state like California. So USCIS and DOL in general, employment should conform to DOL rules. The DOL rules have a minimum wage requirement. That being said, USCIS goes one step ahead and says unpaid internships are okay during the initial OPT. So unpaid internships, again, unpaid internships means a company does not have to pay. That being said, they cannot violate DOL requirements. So if there is a kind of a training program, an internship program that in general does not pay, it's an unpaid internship kind of a program. If it's an industry accepted standard, some internships are industry accepted standards. So an unpaid internship is allowed during the initial OPT. So what that means is if somebody is going through a training program, an unpaid internship at some company, they are working for 20 hours or more. They're getting trained for 20 hours or more. If that is happening, even if they don't get paid, because it's an unpaid internship, because it is not violating any DOL requirements, DOL minimum wage laws, if that is the case, USCIS does not have a problem. So somebody can be without a paycheck for the entire 1 year of OPT program, the first entire year, no paychecks. If they got trained for 20 hours or more, USCIS should not have a problem. Okay, so what that means is paychecks are not mandatory as long as somebody is getting trained for 20 hours or more. You just have to make sure that you're not doing a job that requires payment in general, because DOL does not want the OPT program to undercut a US citizen's wages. So they're very, very clear about it. So if it's a training program, USCIS does not mind and pay statements are not required. That being said, there is an extension to OPT. So once the first year is over, some STEM programs, they are eligible for 2 years of additional time. So 2 years of STEM OPT extension. During the STEM OPT, USCIS has a very, very strict rule. Unpaid internships are not allowed. It has to be a paid job. And not only a paid job, one also has to do a 983 filing with the school. And in the 983 filing, the employer has to certify the wages that they are giving. And in general, the wages are supposed to be industry standard wages. You cannot use the OPT program to depress the wages and give a very low salary. So as long as somebody is meeting the industry standards for that particular location, for that particular occupation, USCIS will be okay. So the bottom line is, first 1 year, if you don't have pay stubs, but you still got training, you're fine. But for the 2 years of STEM OPT extension, you have to have pay stubs. And if you don't have pay stubs, you could run into an issue. That being said, the total unemployment period for the entire OPT program, 1 year initial OPT plus 2 years STEM OPT extension, is 150 days. So up to 150 days, even if somebody is staying home, USCIS is fine. The minute you cross 150 days, you're violating your status. So everybody just be aware of this rules. How much is the maximum time you're allowed to be unemployed, and also the maximum time you can work as an unpaid intern. This is something what every student should be aware of, because these things are very, very common when you apply for your H1. USCIS will come back, they will attack you, and they will request all these documents to prove that you did not have more unemployment, to prove that you did get paid, and also to prove that you only worked in the field of your study. You cannot be a computer science person and you cannot go and work in a grocery store. That does not count as the right employment. The employment has to be in the field of your study. Okay. So overall, if everybody takes care of these things, you will be maintaining your status and you will not see any surprises during your H-1B filing.
Absolutely. It's very important to know where you're at and where you can be, and so that you will not be overused. I mean, sometimes people just exploit, I think, the chances. And friends out there, definitely, you can also contact Attorney Chand Parvathaneni, and you can even have some of your doubts cleared. You can mail him directly at law@spblawfirm.com. And also call him in the number 817-523-8247. And don't forget to check out their website, sbblawfirm.com. Yes, friends. And it's very important to have an attorney, I think, so that, you are doing your forms right, you are applying the right way, and it's important to know the rules and regulations also, right, Chand?
That is correct. And again, students get a lot of help. Even if they don't have an attorney, sometimes they can just go talk to their school DSO. Sometimes they have an international student office. So they are able to get a lot of help. The main thing is keep talking to your friends, keep talking to your school DSO if you have any concern. Make sure you're educated. In US, there is something called ignorance of law. Ignorance of law is never a defense. So if somebody violates a law because they're not really aware of it, it is not intentional, it is just ignorance of some regulation, that will still come back and bite them back. So what that means is people have to be aware of all the regulations and keep using all the resources that you have. And in general, what that means is talk to your school DSO, talk to your school international office, talk to your friends, your seniors who passed out, who have been out in the industry right now. So by keeping aware of all these regulations in general, the chances are minimized, because the rules are simple. Sometimes people just overlook them, and taking help of all these resources make sure that your career is never jeopardized.
Absolutely, it's important, and it's important to know everything. I mean, important things, especially rules and regulations, and yes, just make use of the resources. So, students out there, you are safe. You don't have to spend too much on an attorney. You have help from your institute as well. So, find that out. And Chand, what are the consequences for international students not complying with OPT payment regulations, and how can they resolve any arising issues?
Sure. So, so somebody's on OPT and they don't get paid, which does happen. Sometimes it's probably because they don't have a job, and the maximum allowed period. So there are maximum allowed limits: 90 days initial OPT, 150 days the entire OPT. If you have STEM OPT, so if you cross this time period and you don't have pay statements because of this issue, you could run into an issue. And normally, what happens is when your company files a H-1B, when your company files a H-1B, USCIS, if they notice from your I-20s, because they have access to your service records, if they notice in your service records that you have employment, and sometimes your pay statements don't make sense to them because you do have to include pay statements as a part of your H-1B filing. And sometimes if they feel that you might not have got paid or you might not have worked like you're supposed to, what will happen is they will issue an RFE and say, hey, can you please provide all your pay statements, your employment history for your F-1 OPT period, and prove that you got paid. So this is a very common question. And if you have all the pay statements, not an issue. If you have all employment verification letters, not an issue. But very, very commonly, it does happen that people have some holes in their employment history, which means they did not work for some time. Or sometimes what happens is they did work, but their employer did not pay them because there are some unscrupulous employers. And sometimes people don't get paid like they're supposed to. So sometimes what that basically means to you is USCIS issues you an RFE, requires your pay statements for the entire OPT period, whether it's 1 year or whether it's 3 years, including STEM OPT. You're required to present those pay statements. You don't have it, you still have to go back and explain what happened. Did you have more unemployment than allowed? Or did you have a problem with your employer? Did your employer not pay? You're supposed to answer it. And the consequences are, if you're not able to prove, you're not able to document your pay statements, they could deny your case. And there's a big potential for that. And in general, on the USCIS side, the company side, what happens is there are two things that the company requests during H-1B filing. One, the company wants a H-1B approval. Two, the company wants a change of status approval. So the company says, we want approval changing the status from F1 to H1. So what happens is if there are issues with your pay statements, USCIS will go ahead and could approve the H1. They might not approve the change of status. The change of status is very important for a lot of folks because when you get change of status, the change of status for H1B, what it means is somebody can stay in US and continue to work on H1B status. So the change of status is very important for a lot of folks. And when you have discrepancies with your pay statements, typically what we suggest is we go back and ask for counselor processing. We'll say, okay, let's not, because the employee failed to maintain status, there is some genuine issue. We explain the issue, and then we go for counselor processing. So if anybody has any issues with pay statements, anybody has like, you didn't get paid during your STEM OPT, you're supposed to get paid, but there is a problem and you failed to maintain your status. What we typically say is make sure your attorney knows about it before the filing. Request them to file your case under counselor processing. When you file your case under counselor processing, typically the pay statements do not become a big issue at all. If it is counselor, USCIS typically will approve the case, even if there is an issue with your pay statements. So the bottom line is any challenges with your pay statements, any discrepancies with your pay statements, the way to overcome it is through counselor processing. Do not request for change of status. If you request for change of status, you could have a problem. So, and talk to your employers, talk to your attorneys about the counselor processing and the difference with change of status, because there are two ways H-1B can be filed: counselor processing or change of status. And depending on your situation, if there are problems in maintaining status, The only way to overcome that is by filing it in consular processing.
All right. So, friends, I do hope that you can resolve all your issues and get help, proper help, and be on the right path for sure. And very happy to see a lot of viewers already asking questions. So, hi to Sankart, Bhavin, Veshu, Unit Siddharth, Charan. Big hello to all you folks out there. Thank you for dropping in your questions and thank you for joining us. Stay with us, please. We are going to take up your questions for sure. So, Chand, I also wanted to, if you could answer this, how can applicants effectively address criminal records or legal matters that may affect their F1 status and future immigration applications?
Sure. I definitely want to touch on the criminal records, the criminal violations when somebody is on F1 status. The reason is a few years back, it was very, very rare to see somebody with any kind of a criminal record. The max we used to see was probably a small traffic ticket, like a speeding violation. However, lately what's happening is I think I'm seeing more and more issues, and the most common issues that I'm seeing, at least in my practices, is somebody got arrested because they were driving under the influence of alcohol. Somebody is driving drunk, they got arrested, and when somebody gets arrested, they are fingerprinted, and that record is out there, and so pretty much USCIS will know about it. So DUI, driving under the influence of alcohol, very very becoming a very major issue. So I want everybody out there to be very, very cautious about DUI. DUI has severe consequences with your immigration, and we'll talk about it. And another issue that I see is somebody getting arrested because they've taken some drugs. Unfortunately, some folks they have been taking drugs, and so for example, marijuana, weed, it is legal in a lot of states. And what that means is if a US citizen takes, for example, smokes weed in state of California, state of Colorado, it's completely legal. It is a legitimate drug that anybody can do in California, Colorado, and a bunch of other states. That being said, when it comes to somebody on an F1 visa, international non-immigrant, even if it is legal for a US citizen to do that, from a federal perspective, like a drug like weed, marijuana, it is illegal if a non-immigrant does it. So the common question we get is, a lot of people get confused. They are like, in California, in Colorado, or all these states, because it is legal, because people can smoke weed, do marijuana, why is it illegal if I do it? Unfortunately, in US, there is something called state law and federal law. So according to the state law, a US citizen might be able to escape, but a non-immigrant might not be able to escape if they violate the federal law. So the bottom line is, stay away from those drugs, even if it is legal under the state law. Even if your state says it is legal to smoke weed, stay away from it, because immigration wise, you will have a problem. Another common issue that we see is thefts, sometimes accidental, sometimes intentional. Somebody goes to like a grocery store like Walmart, and sometimes it's accidental, sometimes it is intentional. You're trying to steal something thinking that nobody's watching you, because in these big grocery stores you have self checkouts, so people think that nobody is watching and they do a self checkout. The reality is they have very very complex ways of detecting theft, and people get caught. And sometimes, even if it is a small theft for like $5, $10, immigration wise, you will get arrested. If they find that you have stolen, even if it's a small item, people get arrested. And something like a theft could have enormous consequences on your immigration history. So the first thing I want to tell everybody is, people are getting into these small things. Not many. Again, definitely 99% of the people are always people who follow the rules. It's very few, but again, our goal should be, it should be zero. So what that means is, be aware that these things are happening, and once you're caught, it's too late. You will have serious repercussions, because in US, everything, criminal records are public record. People will be able to just Google your name and find out that you have been involved in this kind of a criminal offense. So just be very, very cautious. That being said, if you ever get arrested, even if it's a small crime, don't deal with that crime by yourself. Go to an attorney in that particular jurisdiction, in that particular city. Take help of an attorney. Let them know that you are on a visa, because when you are on a visa, the way the crimes are handled, it's a little bit different. You just don't take any plea bargain. Just because they say we'll give you a plea bargain if you plead guilty, does not mean that you're supposed to take it. So it's a little bit complex. So definitely engage an attorney, not an immigration attorney, engage a criminal attorney, a lawyer that knows about criminal laws, and make sure you handle your case the right way by following the process. And don't take it easy. If you have an arrest record, what will happen is you will see your visa getting revoked. Very commonly happens. I see somebody getting arrested for DUI, driving under the influence of alcohol. 1 week, 2 weeks, we'll see an email. An email will come from the consulate, Department of State, saying we are revoking your visa, prudential revocation of your visa. So it happens all the time. So, and then you're going to have sleepless nights and so on. So be very cautious about the criminal records. Some criminal records will get you deported. Some criminal offenses, you can handle them. And the general rule that everybody should know is there are two types of crimes: crimes of aggravated felonies, and then crimes of moral turpitude. These two crimes are typically what will get you deported. And in general, these crimes typically have a jail sentence of 1 year or more. So typically, if you ever get charged with a crime that has a sentence of 1 year or more, generally there is a problem. If you get arrested for a crime that is typically like a misdemeanor C, you might be, if it is like a one-time thing, you might be able to overcome it, and maybe save yourself from not getting deported. Okay, and again, not every crime will get you deported, but every crime is going to stay on your record. So sometimes if it's a small crime, if it's a misdemeanor C, you will be able to avoid harsh immigration consequences. That being said, tomorrow your employer is going to search, do a background check, all this will pop up. So just be cautious, and some crimes will get you deported. And from your perspective, anytime you are arrested, if you are arrested, unfortunately, for any crime, document everything and keep records of everything. You have to keep record of the police charge sheet, the initial charging document. You have to keep the initial petition that the DA office filed in the court, and also the final court judgment. So these three are very, very important things. Unfortunately, if you have got arrested and have to go through this bad process, make sure you document and keep all these documents. Provide them to your attorney when they do the H-1B filing. And the criminal records, they should be a part of the filing. You should explain to USCIS what happened, and uh, try not to repeat that mistake. One time, probably you can get a petty offense exception if it's a small crime. But second time, if you do it, you will have very, very severe consequences. So just educate yourself and educate your friends, and stay away from any kind of criminal actions.
Absolutely. Avoid all troubles, friends out there. Why get yourself into all these troubles, right? So hopefully, you know what is right by now, since Chand has also, given us a heads up, given us tips, and let's avoid troubles and just do stick by the rules. It's very important. So all the best, I would say. And yeah, there are more people asking more questions, but I got more for you too, Chand. So are there waivers or exemptions for F1 students with criminal records or legal issues impacting their OPT and CPT eligibility,
Sure.
since we're talking about it?
Sure. So again, depending on the kind of the crime, there are exceptions and there are waivers. So if it's a small offense, there's something called a petty offense exception, and somebody might be able to get away. So again, it depends on the severity of the crime. There are some offenses where the consequences are very severe, even if it's the first time. Something like an aggravated felony. You went and maybe like killed somebody. Murder is like an aggravated felony, and almost always the consequences are very, very harsh. Something like rape has very, very harsh consequences. Something to do with drug trafficking, very, very harsh consequences. That being said, the crimes that we typically see, the small crimes, which are common, are like driving under the influence of alcohol. That's the most common crime. And petty thefts for like very, very small things. Those thefts, those kind of crimes, maybe you should be able to have an exemption if it's a one-time thing, and maybe you're going through the entire process. You're going through the, if you get a probation, or you got some deferred adjudication. uh, so depending on the crime, if it's a small crime, typically there are exemptions, petty offense exemption, and so on. If it's a severe crime, it is very, very hard unless there are other mitigating factors that come into play. But if not, it's the severity of the crime that defines the consequences. Anything with a jail sentence of less than 1 year, more than likely, it's a crime that you might be able to get some exemption if it's a one-time thing.
Okay, Chand, suppose, as a student, suppose I got a traffic ticket or maybe I did some speeding accidentally. Will it affect my F1 visa?
So speeding is generally a statutory crime. So you don't really have evil intent. It's just that you broke a law. So if it's just speeding,
Mhm.
the consequences typically are not severe until you're a habitual person who speeds and breaks laws all the time. If you get like 10 traffic tickets in a year, that means you're like continuously breaking law. The consequences might be severe. But if it's like one or two traffic tickets that you got, the that is a statutory crime where you might not have an immigration consequence unless you are drunk and you're driving in high speed and you hit somebody. So now you have other consequences. But a general traffic ticket, a simple traffic ticket with a fine that is less than $500, more than likely will not have immigration consequences.
But then it's going to be recorded, right? And the USCIS is going to notice sooner or
Probably
later.
not, because normally what happens is, for a traffic ticket, you don't get arrested, and any crime where you get arrested, you get fingerprinted. So anytime you are arrested and fingerprinted, it goes onto the record. A traffic ticket, normally you're stopped and you're let go. You're not really arrested.
Mhm.
So what I would say is, any crime where you're typically arrested, you're taken to the police station, you're fingerprinted, that's a crime that's definitely going to have some consequence on your immigration history. Any other criminal offense where you're stopped, given a small ticket, and let go, more than likely you might not have a very bad consequence. It's those arrest cases that will have severe consequences.
Arrest. All right. So, friends, I hope you're going to be smart, play smart, and avoid any trouble that you can fall into. All right. And with this, I think this is the first half, and I got some more questions, and I'm sure folks out there also have a lot of questions for you, Chand. But it's time for a short break, so let's go for a short break. And before that, I also wanted to tell you that you can also contact Chand directly. Mail him at law@spblawfirm.com or call him in the number 817-523-8247 and visit his website spblawfirm.com. You can also mail me at nipa@higherightpeople.com or call me in the number 408-335-6444. And definitely don't forget to visit our website, www.higherightpeople.com. We'll be back after a short break, so stay with us.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and today we have a very special guest, Attorney Chan Parvathaneni from SPB Law Firm, Dallas, Texas. And we are touching on the topic F-1 OPT and CPT-based RFEs. And this is our second episode, and we're covering a lot of topics. So I hope this has been very enlightening so far. The second half, so I hope you're going to enjoy as much this whole session and be enlightened. So, Chand, I got more questions for you. And, first off, can you provide guidance on proactively addressing and disclosing criminal records or legal issues during the F1 visa application process?
Sure. So normally, if somebody is arrested, that is when you should think about disclosing your record right away. If you're not arrested, I would not worry about it if you just get a ticket. But say you got arrested, what's going to happen is USCIS, when they process your filing, they will see the arrest record. They will not have the entire data, and they will assume that you have done something wrong and try to be harsh about it. And what that means is, rather than wait for them to come back and start asking you further questions, if you have any criminal history, disclose it upfront. Normally, what happens is whenever you have a criminal record, you probably used a criminal attorney and you got everything documented properly. And as a part of your filing, any kind of an immigration benefit, whether it's for OPT filing or whether it's H-1B filing or any immigration filing, if you were arrested in the past, provide a brief explanation on what happened along with the final judgment of the court. The final judgment is very, very important. Initial arrest record, the petition, they don't matter. It is the final judgment, what the finally was decided by the judge, whether they found you guilty, not guilty, or no contest to the crime. That is what USCIS is looking for. So always put your court final judgment, give a brief explanation, have it documented by your criminal attorney, put it as a part of your filing. That way, it will be very clear to the USCIS on what has happened. They will not speculate on why you got arrested, and that will make it a lot more easier. Not only that, if you've done some crime, you'll also have some rehabilitation process, some kind of a probation, what you did to ensure that you don't repeat this crime again in the future. So all of that also should go as a part of your filing, and that will kind of mitigate any damage and any further issues to your future filings.
All right. Hopefully, friends, you are going to stay safe and don't commit any crime. And what we were talking earlier, I hope that you're not going to repeat any mistakes, especially, right? So, Chand, also, what steps should applicants take if they struggle to find employment during the OPT period while, maintaining the legal status?
Yeah, it's a very good question because right now the economy is kind of bad. There are a lot of layoffs, and for the first time in so many years in the past, this year especially, I'm seeing some challenges like people are facing because the job market is not as great as it used to be, and unfortunately, the rules are very strict. People are required to find employment. They do have certain time of unemployment, but not too much. And sometimes you're struggling to find employment and you're crossing the allowed limits. You have a challenge, and what that means is don't wait until the last minute. Go talk to your school DSO, because your school DSO sometimes they might be able to refer you to some places where there are internships. Maybe even if it's an unpaid internship, take it up during your initial OPT. Don't wait till you get a paid assignment. Even if it's an unpaid internship, you are allowed to take it. If in doubt, go check with your school DSO, and at least try to get in somewhere, even with unpaid internship. That is the key for your OPT, because a lot of times people think that they're supposed to get paid and they decline unpaid internships during their initial OPT. You can take unpaid internships, and when you take unpaid training programs, people are a little bit more okay to take you in. So initially, at least for a start, look at the unpaid options, unpaid internship options. Talk to your school DSO, let them know that you're willing to do unpaid internships if it's becoming a challenge initially during your initial OPT, and at least try to get in and get some experience, some practical training. And the misconception is people think they're required to get paid, and they sometimes decline unpaid internships. Don't decline it, especially during the initial OPT. And doing so, at least you can maintain your status.
Right. So, friends, I think it's important to keep learning. Learning is a very, very unending process, and yeah, I think you should aim to learn more than getting paid. So, hopefully, as a student, you're going to learn and be excellent at what you're learning. So, all the very best to all folks out there who are under the process. So, Chand, also, there are more questions from my end, and This next one is what resources or support services are available for F1 students facing challenges with CPT, OPT, or legal issues during their US studies?
The first resort to anybody should be their school DSO, the school designated student officer. So the DSO, that should be the first line of defense for any student issue. Anytime you run into any issue, talk to your school DSO. Anytime you have some other issue, also engage your school international student office. Every school, because you're on F1 program, the school should have an international student office. Engage them. And if they advise you to go to an attorney, go to an attorney, because initially if it's a small thing, just go to them. And if they say no, this is not something that you should ignore, go talk to an attorney. At that point of time, definitely engage an attorney. That being said, most of the time the school DSO typically should be able to handle. The reason is most of the issues are trivial, nothing legal during the F1 period. That being said, be in touch with your school officials.
Okay, Chand, like, is it okay to have a 1 year unpaid internship? It's a long time and a lot of hard work, I guess.
The initial OPT, even if it's the entire 1 year of unpaid internship is acceptable. Only thing is they need to get trained for 20 or more hours a week. As long as that is happening, it is acceptable.
Okay. All right. So I hope this is going to be good for everyone out there and not so challenging. Keep learning, friends, I would say. So, how crucial is it for F1 students to seek legal advice, or representation when dealing with CPT, OPT, legal challenges during their studies?
Uh, for most of the folks, they typically don't run into any legal challenges initially because they study. And what they're supposed to do is make sure you are passing your classes every semester. If you're doing it, you're good. If you get into academic probation, you have a problem. That's when you probably need some legal advice. But if you're studying like you're supposed to, you're passing your courses, you're progressing towards your degree, you're probably fine. And the next major thing that the students come across is filing for their employment authorization, their OPT card. Filing for OPT card is very simple, and 99% of the time, the school DSO or the school, they will assist you. So again, during your studies, if everything is normal, you typically will not require a lot of lawyer help. That being said, everybody's case is different. If you run into a situation where you think it is unique, always engage an attorney. But if not, just make sure you're finishing your school, you're progressing towards your degree, you apply for your OPT card during those timelines. There are strict rules on how you should apply for your OPT. It's very simple, but there are some strict guidelines. So make sure you follow them and you get it done. The next big thing is the H-1B process. Normally, you always find an employer, and once you find an employer, the employer will assist you, and the employer typically they will engage legal counsel accordingly if you require any legal help.
Okay, could you probably give us a tip for the same?
Um, normally, I mean, again, when somebody is getting employment, the employer has to file the H1, and during that time, they analyze the entire file of the student, and if they see some issues regarding maintenance of status. So anytime you see issues with maintenance of status, I think you should engage legal counsel. And if you're, because everybody's case is different, most of the people, their status is good. Some people have challenges with maintaining their status because either they didn't work like they're supposed to, or because they had bad grades in one semester. So something you think is bad where somebody could point out that you fail to maintain your status, definitely engage an attorney.
And just suppose, okay, I mean, hard luck. Maybe I got unlucky, fell sick, they couldn't get to attend class, neither could I do my internship properly. What could I do in that situation?
So normally, if somebody has a major issue, the school DSO will say that they have to get their F1 reinstated. For some reason, if the service gets terminated or something happens, the school DSO will typically
Mhm.
advise somebody of F1 reinstatement. And if somebody needs F1 reinstatement, it's a process. And normally, that is one area where people typically engage a lawyer. Their F1 is gone, and now they're supposed to get back onto F1. There is a way. There are a couple of ways to get back onto F1 reinstatement. Definitely, they might need some legal counsel during those times.
Okay. So not all in all unlucky, but there will be a way out. So friends, to all problems there are solutions, and it's always good to get advice from the best. So contact your DSOs, and definitely, if you can, contact attorneys so that they can help you out and guide you throughout the whole process. And lastly, Chand, what advice would you give? Would you offer to F1 students transitioning to OPT or H-1B status?
So the main advice is make sure your service is active until you get your H-1B. Service has to be active. You cannot get your service terminated. Very important. And find a good employer. Anybody that's converting to OPT or H-1B, your immediate goal is to find an employer. Make sure your employer is a legitimate employer, not any unscrupulous employer. There are a lot of people who are unscrupulous employers. We unfortunately had to deal with a couple. People get NOIDs and NOIRs. H-1B gets approved, but then they'll get a notice of intent to revoke or notice of intent to deny because USCIS found some problem with the employer. This happens all the time. And what that means is you guys are getting into the real world, the real working world for the first time after you finished your classes, your school. And finding the right employer is super important. You guys are highly qualified, but if you find a bad employer, it's going to mess up your career. You'll get an approval, but down the line, you could get a revocation. So what that means is always research who your employer is, get some referrals, make sure you're comfortable with the employer, make sure you have enough referrals who tell you that the employer is a legitimate employer, no issues. Only then take up employment with them, because when you're finding a job, you do have choices. If not one employer, you have another employer. So just don't take the first employer that is willing to file your H1. Do your own research. Make sure only you work with a legitimate employer for your H1B filing.
All right, friends, do your research properly. That's, I think, it works in all cases. Proper research is going to help you out all in all. So whether you're a student or going to get a job very soon, do your research properly and only then, move forward. And definitely, if you have questions directly to the attorney, don't forget to mail him at law@sbblawfirm.com, or call him in the number 817-523-8247. And also, check out his website, sbblawfirm.com. And Chand, yeah, I we got a lot of viewers asking many questions. So it's time, to take up questions from them, and let's do this. Starting with Sankirth. How can applicants address challenges related to maintaining F1 status during the F1B filing process?
So during the initial filing, what you're supposed to do is make sure you have all your I-20s. All your I-20s have updated employer information, because you're supposed to notify your school whenever there are any changes to your employment. So as long as you put all your I-20s, your pay statements, and normally what we suggest is at least the last 3 or 4 pay statements before you do the filing. You should put those. I don't think you need to put everything from your OPT period, but at least the last 3 or 4 before your H-1B gets filed. Put those pay statements, put all the I-20s, and your transcripts will show that you passed your coursework. That will reduce a lot of your RFEs regarding F1. That being said, even if everything is good, OPT RFEs to show that you maintained a full course of study, you attended classes. These kind of RFEs are very common, and normally what that means is, as a student, you should keep records of every class you attended, all the places that you have lived at, all the places that you worked at, all the employment records. You should always keep it handy, because when you get an RFE, the only things they can ask are prove that you attended classes, prove that you passed classes, prove that you paid your tuition, prove your residence history, prove your work employment history. These are the common things that get asked. And from your perspective, keep the documentation about your employment, your residence, and your attendance. Attendance in college is very important. And if I just show the transcript and say I passed all the classes, that's not enough. USCIS, for some reason, they also keep insisting on attendance records. So always keep your attendance records. And when I say attendance record, a simple letter from your school sometimes saying you attended all the classes like you're supposed to, physically, not virtually, that also will satisfy. So as much as possible, keep all your attendance records and all these other records I just mentioned.
All right. So out of 100, how much percentage of attendance is minimum, you would say?
Normally they're supposed to undertake full course of study. So in general, what I see is 70% or more attendance is normally enough. That being said, every school is different, and it also depends on the professor. So if
Right.
the professor agrees that somebody has attended full course of study in person, the reason is USCIS wants to make sure somebody is not attending classes online. Online classes
Mhm.
don't count. So a certain number of hours has to be physical presence in the classroom, and that is what they're trying to make sure. During COVID, we had some exceptions. We got some relaxation for online classes, not anymore. So right now, they still have to prove that they have class attendance, in-person class attendance. So it's a very common RFE that many of you folks will see. And even if you do everything right in the first initial filing, it's an RFE that some people get still be issued with. So just be prepared with all the documents. Don't wait until the last minute. This is something what everybody should keep handy.
True. All right. So I got this next one from Bhavin. How can applicants overcome challenges related to gaps in employment history during H-1B cap filings?
So again, gaps are okay. Only thing is you cannot exceed 150 days of gap for your entire initial plus STEM OPT, the total 3 years. You can have gaps. As long
Okay.
as those gaps don't add up to 150 days, you're fine. Unfortunately, in your case, say it is more than 150 days, let your attorney know, because the way to overcome that is by requesting an approval in counselor processing. If you have a problem, you have a gap of more than 150 days of employment, easiest way is to just request counselor approval. And what that means is you have to go out for stamping and then come back. Normally, it's not an issue. You step out of the country, you go for stamping, you come back, it will resolve your this employment issue. So definitely let your attorney know, because if you have a gap, a lot of gap, counselor processing is the way to approach rather than to request change of status.
Right. So, Bhavin, wherever you're planning to go, I hope you come back early. And this next one is from Veshu. What are the essential documents needed for an H-1B cap filing, especially in the context of F-1 OPT or CPT transitions?
So everybody's both F1 OPT and CPT, you need to have your I-20s, and I-20s should correctly reflect your employment history. So that's very, very important. And normally everybody has I-20s most of the time. 99% of the time, your I-20s are updated with your right employer information. So that is very critical. Your recent pay stubs are very critical. And that being said, for CPT, I think if at all you have CPT, you typically should submit at least your CPT agreement. Everybody that takes CPT, they're typically authorized by the school. So the school will go ahead and authorize the CPT participation. So a letter from from the school or a CPT agreement, something that shows that your CPT has been authorized by the school, that is very important. OPT, it's very easy. OPT, all you have to do is just show your OPT card. So include your OPT card if you have taken OPT. But if you have taken CPT, always include your CPT agreements and details about your CPT. What is the CPT course that you're doing? The CPT information about the CPT program in your school. So typically, your school will have information about the CPT program. Try to include that as a part of your initial filing, and that will definitely reduce the volume of CPT RFEs that we encountered.
Okay, so Veshu, I hope you got your question answered and definitely watch the whole episode and also the previous episode under the same topic. I'm sure many of your doubts will be cleared. And so this next one is from Uneet Siddharth. What are the key differences between F1 OPT and CPT employment that applicants should be aware of during H-1B cap filings?
So F1 OPT, it's very simple. It's F1 OPT is authorized by USCIS. So USCIS know that the employment is authorized when they gave you the OPT card. So OPT, the very simple thing is you put your I-20s, you put your pay statements, you're done. CPT, on the other hand, not everybody gets CPT. Only some schools let you do CPT. It also depends on the program. And what that means is uh, you should be aware that CPT is something that the school has authorized, not USCIS. Because of this reason, you have to include a little bit more documentation about your CPT. What exactly is the CPT course that you have taken? Why is CPT an integral part of study at your school? Your school will have the documentation on why CPT is required for your school. And also the DSO, where the DSO or the school approves your CPT. Typically, every school will have a CPT agreement a CPT agreement that gets sent to your employer. So that CPT agreement will show why the school has authorized your CPT program. So that is so the main difference is CPT is authorized by your school, OPT is authorized by USCIS, and based on that, you have to keep all these documents as a part of your filing to minimize your risk of getting an RFE.
All right. I'm sure, folks, you have a lot of questions and maybe you need to clear some doubts and be guided by an attorney. So you could also contact Chand himself, Chand Parvathaneni. You can mail him in the mail ID law@spblawfirm.com or call him directly in the number 817-523-8247 and go visit his website, spblawfirm.com. And you can even mail me also at nipa@higherITpeople.com or, contact me in the number 408-335-6444. And don't forget to check out our website, www.higheritpeople.com. And Chand, there are many more questions. If you have some more time, I'll take up the
Sure, sure.
rest.
Yeah, go ahead.
All right. So this one is from Charan. Charan from YouTube is asking, what are the most common types of request for evidence, RFEs, related to F1 OPT and CPT-based H-1B filings?
So F1 OPT is very simple. So whenever they issue an F1 OPT RFE, they simply want your employment history and they want to count your unemployment days. So basically, all they're saying is provide the dates of your employment, your employer list, and proof that you got employed for 20 hours or more. If you have pay statements, very, very easy. You put the pay statements, get an employment verification letter, and submit, you're done. The challenges are if you don't have the right employment and you have a lot of unemployment days, then it's a challenge. But if not, you just document your employment history, your pay stubs, you're done. CPT, on the other hand, has a lot more challenge. So for the CPT, they're going to ask you for documentation that shows that CPT is required for your program. So something that says your school requires participation in CPT. That is very, very important. They also want to know what is the course code and what is the course description for the CPT course that you have done, because CPT is technically a course. They also want to make sure your school has authorized the CPT. So they will ask for documentation from your school. They will also ask for documentation that you're actually attending school physically, because the most common universities that I see for CPT are Cumberland's, Campbellsville, and there are New England College. There are a couple of schools that we routinely keep on seeing it. And a lot of times what happens is somebody is working, say, in Dallas, or somebody is working, say, in Atlanta, and their university, Campbellsville or Cumberland's, is in some other city. So very commonly for CPTs, they also ask for travel receipts, proof that they actually traveled to the school, and attendance records. Attendance records are super important for CPT RFEs because USCIS is trying to make sure you are doing CPT, but you're also actually traveling all the way, actually attending classes physically. And that is a very big part of CPT RFEs, proving that you physically attended classes even though your employment was like thousands of miles away. So overall, CPT is a little bit more challenging in terms of documentation. That being said, we typically don't see denials, very rare to see denials. The reason is most of the folks, they do attend classes physically. They do CPT because CPT is required by their school.
All right, all right. So, well, I got Charisma Gillen. I think one of our regular viewers, because I remember the name. So she asking, a couple of weeks ago, my initial H-1 application was revoked by USCIS based on in-house project. Intent to revoke notice was sent to my employer before renovation, which I was told after revocation.
Revocation. Okay. So, from what I understand, I think your case got revoked, your prior case. And there are two ways to look at this thing.
Actually, there's a follow-up. There's a follow-up saying, I just filed my H-1 transfer in premium and waiting for response. Not sure whether it's gonna happen. Just taking my chances. I am in a very vulnerable situation. What other alternatives can be done? So this is the
Yeah.
situation.
So I think what has happened is your H-1B, the prior H-1B got revoked. And we occasionally see companies where cases get revoked And that's what I talk about unscrupulous employers. The problem is you don't think something is wrong. And like in your case, what happened is your past H-1B from a long time back got revoked. Uh, and it is revoked by USCIS. Anytime USCIS revokes a H-1B, there is always a problem. From your perspective, there are two ways of looking at it. Is this the base petition or is it not a base petition? And a base petition means the very first petition that got picked up in the lottery. If it is the very first petition that got picked up in the lottery and that got revoked by USCIS, there is a problem. Your transfer also might be jeopardized. Your transfer might not go through. There is a good chance USCIS will come back and argue and say, your transfer cannot go through because your base petition, your initial petition that got through the lottery got revoked. And they will conclude that you're not cap exempt anymore. There is that big risk. And what it means is if they come back and say you're not cap exempt anymore, you have to go through the lottery again. So anytime the base petition gets revoked due to fraud, due to misrepresentation, or USCIS revoking that H-1B due to some other reason, more than likely, you're not cap exempt anymore. You have to go through the lottery process once again. That being said, this is March. I mean, next week is, from tomorrow it's March. The lottery process is starting. Since your transfer got filed in premium, more than likely in the next week, you will see an answer. If at all they're talking about your previous revocation and they're claiming you're not cap exempt anymore, this is the chance where you can get back into the lottery. Luckily, it's the time of the lottery season. There is a good chance that you will get an RFE for your transfer and USCIS might ask you to go back into the lottery. Again, if it is not a base petition, I would not worry. But if it is the original base petition that got revoked, you might have a problem.
Okay. So, Charisma, I mean, if you have more questions, definitely just keep commenting or don't forget to mail us for sure. And I'll take up this next one quickly from Jen. I am on my last month of OPT planning to go on day one CPT. My employer has filed the perm and we are waiting to hear from the DOL. Shall I work on another position or same position with my current employee?
So again, for the lot of folks out here, even if you're on F1, your employer can still start the green card process, which is what has happened here. Somebody is on F1, but their employer has filed the perm, which is legal and it can be done. We have done that a number of times. So it's a good thing. Even before you got onto H1, your employer started the green card process, filed the perm, and right now you're waiting to hear from DOL. You can change a position with your current employer because the perm, it's more about future employment. And if you meet the qualifications on the day your perm is filed, you're all set. So you said your employer already filed the perm. So on the day the perm got filed, they talked about your experience, they talked about the job requirements. If you met those requirements on the day the perm got filed, you're all set. Today, if you want to work on another position, you're fine to do. And your employer should not have any issue changing your role if they want to change your role temporarily.
Okay. And this next one on YouTube again is from Kavya. What role does legal counsel play in ensuring a smooth H1B cap filing process, especially in addressing potential RFEs?
Sure. So for somebody like us, so I work on a couple of thousands of H1s a year. Last year, I worked on more than 3,000 H1s in our law firm in a 1 year period. And what that means is, since we work with this enormous amount of filings, we pretty much know each and every issue that pops up because we are bound to see all kinds of issues because everybody's fact pattern is different. And what that means is sometimes we're able to minimize issues even before it arises. The most common issues, using the wrong ONET code, wrong wage levels, or something wrong with the job duties. So these kind of things we are able to predict before something happens. Reason is we have seen these issues so many times, and anytime we see an issue that's major, we are looking at our filings from that perspective. So our way of looking at filings is based on what we have, the kind of issues we've encountered in the past. So we are very narrow in looking for those specific issues in our filings, and that's what any attorney would do. That they have had some experiences in the past, they've seen some RFEs, they try to resolve it. They know what exactly USCIS is looking for. They try to minimize the damage. And the most common ones that I think about are make sure you use the right wage level. Make sure you use the right occupation, the owned codes. Make sure the duties are right. They align to the occupation, not just any random duties. So there are a couple of things that are very important that will impact the the final adjudication, which is why I think normally when somebody who is a part of the process, they exactly know what they're looking for, because it is not the very first time they're doing this thing, and at least they can use their previous experience. So that is the reason why a lot of companies, they typically engage a lawyer, because an immigration law firm, whether it's ours or whether it's somebody else's, some other law firm, they're in this business, so pretty much they're focused and they know what is required. And if regulations change, the law firms, whether it's us or whether it's somebody else, uh, they are typically required to keep up to date with the regulations.
True. So you definitely, I mean, it's going to only benefit you if you have a legal counsel.
And again, RFEs are
And
common.
Rina Joseph,
Yeah, and sometimes RFEs are
sorry,
sometimes
yeah,
RFEs are common. Even if you do everything right, you get an RFE. But I think if you do everything right the first time, even if it's an RFE, sometimes it's an easy RFE. So sometimes something that you can easily handle. At least the complex kind of RFEs, the kind of RFEs that you cannot handle, those are at least reduced.
right. The next one already appeared on the screen by Rina Joseph. How can applicants ensure compliance with OPT payment regulations during H-1B cap filings?
Again, so you can ensure compliance by knowing the law. And the law is, for the first 1 year, you have to work 20 hours or more. You have to get trained 20 hours or more. Pay, even if you don't get paid, unpaid internships are also allowed. So you need to know that regulation. So, and again, for the STEM OPT extension, know that you're supposed to get paid as per the 983. Know that regulation. So as long as you know that regulation, ensure that whatever you're doing, that initial first year of OPT, you're meeting the standard. And for the STEM OPT extension, you're meeting the standard. So you're supposed to look at your 983, see what your employer promised, make sure you make that salary. If you don't make that salary, the employer is not paying you that salary, there are legal recourses, DOL, or sometimes the State Workforce Commission. These are all places where you can get help, because there are some employers, you work, they don't pay you. And if you work and the employer does not pay you, make sure you get the proper legal help. Go through the DOL, go through the Labor Workforce Commission, and address your complaint. And you will have these people assist you.
All right. So I think, Chandra, I'm going to take up the last question from our viewers, and hopefully we can get all your questions answered. This last one for today is from Pradeep. Can my employer file for green card process, PWD and PERM on F1 visa?
Definitely. I mean, we have done that a lot of times in the past. They can file your prevailing wage, perm, and also I-140. Even you can even finish the I-140 while you're on F-1 visa. Unfortunately, nowadays, you see how long it takes for somebody to get through the lottery. So somebody is on F-1 visa for a very long time because they're not getting selected in a lottery, and the employer, because they know that the employee is so valuable, they don't want to wait until somebody gets the H-1B. And what that means is they start the process while somebody is on F-1. They finish up the perm, they finish up the prevailing wage. And if the perm gets certified, they even go ahead and process the I-140. And we have a number of cases where somebody's I-140 is done, approved, but they're not selected in the lottery. And they are getting through the lottery every year, hoping to see the selection in the H-1B lottery.
All right. So definitely a yes for Pradeep. And thank you so much, Chand, for covering this topic thoroughly. I mean, 2 episodes is not a joke, and we had so many questions also covered from the viewers. So F1 OPT and CPT based RFEs, we definitely navigated through the H1 cap filings, and I would only say thank you so much, for this wonderful, very informative session today as well.
Thank you.
Thank you, Chand.
Thank you, Nipasa. And thank you, everybody.
Thank you, everyone. So keep in touch with us, and I'm definitely hoping to see you again next week, Chand. I know March is going to be a very, very busy month for you, especially from March 6th to the March 22nd, the period which is going to be very busy. So
Right, right. And I think
still,
for
I'm hoping
all
to
the
see
people
you.
who joined here who are looking for H-1Bs, we
Right.
wish you all the best. Make sure you talk to your employers. Make sure they don't miss the deadline. March 6th is when it starts. March 22nd, 12 noon EST is when it ends. Make sure you're chasing your employers. Make sure your registration is done. and make sure you follow the regulations. As long as you follow the regulations, I think things will be fine. And this year we don't have the multiple registration issue. Luckily, USCIS took time. They resolved the multiple registration issue this year. So this year, I think the lottery is going to be a very, very fair lottery. I don't think the lottery in the last couple of years was fair. It was a very unfair lottery with all that multiple registration issue. This year, I think for the first time, we will have a very fair lottery. And I wish everybody the best in their careers going forwards.
Absolutely. All the best. And thank you so much, Chand, once again. Have a great day ahead.
Thank you so much.
And folks out there, thank you for joining in today on Immigration and Jobs Talk Show. I'm Nipasa Pradhan. And if you have more questions, definitely don't forget to visit our website at www.higheritpeople.com. And also, if you have more questions regarding this topic or other subjects we've already covered, don't forget to check our channel. We are Immigration and Jobs Talk Show on YouTube. We are also there on Facebook, on Instagram as well, on Twitter, every platform actually. So just be with us, and also LinkedIn, very important. So yeah, you can mail me also at nipa@higheritpeople.com or contact me in the number 408-335-6444. This is the number for my WhatsApp as well. So have any questions, any doubts, please feel free to contact me. And thank you so much. I'm very happily saying bye. I hope that, this session was very informative. And I'm also going to be here again tomorrow at 12 p.m. EST. So don't forget to tune in. Thank you so much for joining us today. Have a great day ahead. Bye bye.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.